Welcome to my YouTube channel, African Dignity. This is dedicated to all the students, the class of 2025 at the University of Zululand. Please subscribe and like this video so that we can have many more. Students, greetings to you. This will be my last interaction with you. I have spoken to the class rep, Ms. Mandisa Ntombela. And I am very disappointed that on the 16th, on Friday, you were supposed to attend the class from 8:30 to 11:30, and not even one of you attended. It's so disappointing, and it proves how careless with your future are you. You are not serious about life. Life is not challenging to you. Next year, you will be expected to follow your principal doing articles. But as far as I'm concerned, judging with your attitude and behavior, you are really not ready for the legal profession. First of all, legal profession, you have to prepare and prepare and prepare. You have to be early. I came to the class, I stayed until 9 o'clock, not even one of you pitched up, regardless of the messages that I sent for. But okay, let me just deal with what we were supposed to talk about yesterday in our lecture. The most important thing is that you are supposed to know the procedure, because we are doing legal practice. So you are supposed to know the procedure that is followed when you issue summons and serving summons. I am very disappointed that students that I've sent to my friends who are attorneys seem not to know a thing about issuing summons, servicing summons, and things like writing a letter of condemnation. And you also do not know anything about something called the practice manual. I've already told you in most of my lectures that when you encounter any word or any concept or any phrase or any idea, a legal idea, you must use your phones. In your phones, you've got something called Meta. When you're using Meta, don't be specific in mentioning names. You just ask Meta maybe to draw. You say, Meta, please draft a heads of argument for a particular case. You'll say heads of argument for an application or to rescind judgment or something like that. But you put the subject as well when you are asking Meta to do it. You can use ChatGPT and use other social media gadgets that can help you to draft. So here we are now. I am saying when you are sent by your principal to go and issue summons, let us say you are issuing an application in the High Court. I told you that applications are done in the motions court. So with application, you will always have a notice of motion that will set dates for the other party to do what? To file their intention to oppose, and also to file after 15 days to file their answering affidavit. So we know that. Now, how you've already done that, now what do you do next? There must be a founding affidavit that will have annexures. Annexures like if you are applying for a rescission. So obviously you are going to have maybe an agreement, a sales agreement, if there's a sales agreement, and you will have the order of the court that said you must do a particular order. Okay, now you know, so you will have those annexures are very important, because like I told you, in the motions court, there will be no need to call viva voce evidence. Everything is done in papers. And I told you to look at the Plascon Evans case as well as the Stellenbosch Wineries case. That's where you'll get the principle that says everything should be clear in your paper so that the presiding officer can be able to make an informed decision based on the papers in front of, of him or her. And I told you that in the motions court, you are actually asking for something called the usual order. The usual order is to say the matter is now trial ready. It can be now postponed to be heard on the opposed roll. Because like I said, when you go to court, if you're going to the motions court, then you must look for the unopposed roll, because everything in motions court is on the unopposed roll. That's where you will be setting yourself on record, putting yourself on record as the defendant, as the respondent, because normally there we do applications. Okay, that is clear. Now, what do you do um, once you have issued the summons? How do you issue summons? So, once you have drafted the summons, then you must issue them. What do you mean by issuing? Issuing means if you are going to a high court, you will be going to a place called the general office, and that is the office of the registrar. That's where you will then give 3 documents to the officers at the general office. They will then look at the papers if they are done correctly, everything is there, signatures are there, and you've got all the necessary parts of that application, like the founding affidavit. Sometimes you must have also a confirmatory affidavit, right? And then all the supporting documents are there and they are numbered correctly. Also, you must learn to do it from the beginning, that when you take anything to court, you must have it indexed and paginated. It makes it easy for anyone to know if the officer at the registrar's office want to find out if the founding affidavit is there, the confirmatory affidavit is there, then they will look at the index and the index will say everything. So he doesn't need to page around and wasting time while there's a queue at the general office. So you have to do the index and paginating. I told you how index is paginating is done. Is first you will write the seat of the court, and then between the 2 lines you write index, and then you will have columns where you'll say item number 1, and then you say items, and the second column will be description, and the third column will be page. So on the first item, you say item number 1, just write underneath, and then under description you say the first one would be, in this case, a notice of motion. Notice of motion normally have about 2 or 3 pages. Then you'll write from 1 to 3 pages is a notice of motion. Then on the third column, on the third column, then you'll write page 1 to 3. You just said 1-3. Okay. So the description now, on the part of the description, it will be notice of motion. Then you come to the next item. In this case, because it's an application, the next item will be the founding affidavit. So founding affidavit maybe might have about 20 pages or 17 pages. Let's say it has 20 pages. Then you write item number 2. Under description, you write founding affidavit. And then on the pages, you'll say from page 4 to page 23 is what is the founding affidavit. You write on the under the column, say 4 to 23, and then you come with the third item. Maybe it's a confirmatory affidavit, which normally is about 2 pages. Then you write 3, and then you write confirmatory affidavit, and then on the page you write 25 to 26. So you've got your papers ready, and anybody who looks at it says this person is professional and he knows what he's doing. So that's how we do it. Then once that has been issued, issuing means it has now got a case number and also a stamp that you were at court to issue it. Then it won't be filed. It has to go and be signed by your opponents. How do you do it? Sometimes if you know your opponents, let's say they have lawyers representing them, you will take it to those lawyers so that they can receive it and acknowledge receipt. But if the opponent does not have lawyers, then you must take it to the sheriff. You will take the sheriff. So sheriffs are divided into areas. You can't just take your papers to any sheriff. There will be a sheriff designated for that area. Which area? The area where the person who is the opponent, who must be opposing this application, resides. So if, for instance, you issue papers in in Durban, and the person stays in Manzimtoti, which sheriff will you use? You will use a sheriff in Imbumbulu Court. There are sheriffs there. You take it there, and the sheriffs will do what? Will serve this person. So you must provide the address and even the telephone number of that person so that they can be able to get hold of him. Then you will then, sometimes some law firms have accounts with different sheriffs, but you can also pay cash at the sheriff. Then you have it serviced to the person concerned. Then after the service, the sheriff will then take that and file it in court. Sometimes they might say, come and collect it. Once you come and collect it, then you'll have to take it to court so that the court can see that this matter is before court and it's the other person has been served and there is acknowledgement of receipt of those papers. Then you are done with servicing. The next thing now will be to do what is called a notice of set down, right? But in the applications, the dates will be there, so there's not that much need for a notice of set down because the dates are there, and the person has seen that this matter will be heard in court at this particular time on this particular date. Right. Then that is good enough. So on that day, you will go to court and place yourself on record, and the other party will place themselves on record. Then you get what is called a usual order. Then the matter will, if everybody is there, the matter will be postponed to be heard on an opposed roll. But if your arguments do not make sense to the presiding officer, they can give an order immediately in favor or against you. If you haven't made your case in the papers, like I said, then an order may be given against you right there at the motions court. So I hope you understand. If you don't understand this, please tell your class rep to contact me so that we can take it further. I hope this is done. Now, let us talk about, let me now hold on this one and do another. I am going to do another one where you will be learning something else. Okay, because this is now the first class. Now we will be going to another period, which is from 9:30 to 10:30. Then we'll do another one from 10:30 to 11:30. Thank you.